Afternoon. We're just giving it a moment as folks trickle in from our waiting room. Okay, we're gonna get started. Thank you everybody for joining us. My name is Megan Good, a she, her pronouns. I'm a staff attorney here at MVLS, part of our Tangled Title team. And MVLS is an organization that aims to reduce barriers to justice by engaging members of our community, advocating for equitable laws, and providing free legal services, free civil legal services. Many of you are volunteers with us helping to carry out our mission, and so thank you for that. We appreciate your support. I will provide my contact information in the chat towards the end of this session. If you're joining us and you're not currently a volunteer and you'd like to learn more about what it means to be a volunteer with our organization, you can connect with me directly and we can answer any questions. Also, if you're currently a volunteer and want to learn more about using life estate deeds, you can reach out for that support as well. We have selected the topic of life estate deeds for a training because they play a really important role for the folks that we're serving in our communities. As part of the Tangled Title team, we're trying to help preserve the family home for low-income homeowners. And many times, folks that we serve don't have their names on the deed to their home because they maybe inherited the property from a family member, but there was never a deed to transfer ownership into their name. And that creates a host of issues for individuals. They fail to qualify for different programs that might help them to maintain the home and afford the home. It also prevents them from being able to transfer the property. So when we're working with clients, life estate deeds are a tool that we often talk to them about because it can help to facilitate that transfer of their property onto the next generation. So our focus today is life estate deeds. Our presenter is David Thurston. Very excited to have him join us. He's the president of Crown Title Corporation and the law offices of David L. Thurston. He's both an experienced real estate attorney as well as a certified public accountant. David will lead us through the rest of the session. I will interject sometimes with questions. As we were preparing for this training, David wanted me to let you know that he invites questions throughout the session. So you can use both the chat feature or the Q&A feature in Zoom to share your questions with us. And we'll try to fold them into the training as we go. And if some maybe aren't directly relevant to the topic that we are presenting on at a certain moment, then we'll save them for the end and address them at the end. You should have all received a notification when the training started that this is being recorded. We do record our trainings so that we can make them available to individuals who are not able to join the session. So just let you know about that. And finally, we will share these slides afterwards. So you don't need to furiously take notes. If you want to write down the information on the slides, we will be sharing them with everybody. So with that, I'm going to turn it over to David to further introduce himself and begin the presentation.
Thank you, Megan. As Megan said, I am the owner of Crown Title Corporation, which is a national title company. And I've been practicing law in the state of Maryland, in Washington, D.C., and New York for 32 years now. And I'm also a member of the Maryland Institute of Certified Public Accountants. So happy to be here, happy to answer questions as we go. And I'm going to start the presentation once I navigate the share screen here. Slideshow from the beginning. All right, hope everybody can.
David, I'm going to jump in. If you can, at the display settings, swap presenter view. Yes, perfect. Thank you. Here we go.
Okay. All right, life estate. So just an overview. We're going to try to review the instruments of transfer, how you pass title in Maryland, what the two life estate deeds, the differences in the two life estate deeds with or without power. Talk a little bit about Medicaid. If I slip and say Medicare, that's my fault. I do it frequently, but we're talking about Medicaid liens and not Medicare. and then do a couple case scenarios. Like I said, questions can be asked throughout, and I'll try to make this as entertaining for you guys as possible. So you can pass title to property in Maryland one of two ways, either through will or through operation of law. Will creates problems in, especially probably if your clientele is that wills are frequently lost, and then there's cost to probate the will, and there's administrative procedures. What we try to advise our clients is to try to pass all the assets by operation of law. So you want to do a deed that's either a deed with a right of survivorship, or you want to change your 401k to a payable in death. You want to change your bank accounts to a payable in death. Frequently, they'll have a child that they trust, and they can add them to the bank accounts. So when you're looking at an estate plan, you really try to use a will just as a safety net in case you forget an asset. I would tell you 9 times out of 10, the asset that's forgotten is the car. And that's the one that ends up throwing a little bit of a monkey wrench into it. But you would certainly, for anybody with less than a taxable estate, which is 20 million on the federal side, you would always try to use payable in death and deeds with remainderment to get out of those, to avoid probate. Now we'll go to irrevocable trust. Again, there are some costs here to create an irrevocable trust, but that is probably one of the better ways to do it. A revocable trust can also be used, but a revocable trust does not put the assets outside of the purview of creditors or Medicaid. So an irrevocable trust is you would create this trust, you would designate the remainder people, designate what should happen upon your death. So basically the trust has two provisions. How are the assets administrated while you're living? And then what happens, who is the trustee, and what happens to the assets after you pass? It is a will substitute. It does avoid probate. It is easily amended. And the transfer of a property to a trust within the 5-year look-back period may render a period of ineligibility for Medicaid, but so will really anything you use. You're going to have that 5-year look back if you're doing it for less than fair value. So that's, to me, that's just kind of part of the game, which is the way Medicaid works. But again, the problem probably with your clientele is the formality of the trust, because creating the trust is only the first step. You have to actually fund the trust, which is transferring the assets to the trustee, to do the administration of it. So it may be too complicated for some people to grasp, but it is used frequently as a will substitute. On the real estate side, having a joint tenant or a tenant by the entirety deed. So in Maryland, you can only a married couple or a couple who is elected to be a domestic partnership can hold property as tenants by the entirety. Everyone else that's not either married or has elected domestic partnership has to use joint tenancy. So this deed is created. Owners have an equal interest in the property. It's very, very important. You can't have a 2/3, 1/3 joint tenant. There has to be what is known as the 4 unities of title. And one of those 4 unities is they must have equal share. You can't have unequal shares with a joint tenant. You're still within that 5-year Medicaid look back, but you do get a right of survivorship. So as soon as one party passes away, the other party will own 100% of it. It is initially out of the reach of creditors unless they attempt to levy on the property. I can explain that later on when we get through some of these other slides. And the only thing you have to watch when you have a joint tenancy deed, so if mom and son were joint tenants and son files bankruptcy, that tenancy is broken. And as operation of law, it goes to tenants in common. So how does that impact the property? Well, if it's a tenant in common property as opposed to joint tenants, creditors can reach it easier, and you don't have a right of survivorship. You don't have a right of survivorship. So that's the only thing you have to watch with joint tenancies if one of the parties would file bankruptcy. In our world, when we're examining titles, unfortunately, that happens a lot. And then you have to explain to the people that it's become tenants in common and one of the parties' judgments have attached. It's not a great conversation to have, and unfortunately it happens. Life estates. So you can do a life estate with or without powers, and we'll tell you some of the advantages and disadvantages in a moment. But basically, if I own a property and I want to do a life estate deed and I want to do a remainder to my children, I decide whether I'm going to hold a full power or a limited power or no power life estate. So that's the first thing in the deed you have to consider. Are we doing a full power or a no power? The remaindermen in a no power life estate receive an interest day one. It is a lifetime gift, and they really take control of the property, subject to the life tenant's ability to live there. In a life estate with full powers, the life estate holder still retains the powers to mortgage and sell and those types of things. The measuring life, the person whose death will trigger the passing of the full estate, the property, to the remaindermen, this will often be the life estate holders. 99 times out of 100, it's the life estate holders. And that is one thing you can do when the property is sold. If it's a no power life estate and the life tenant is living, there's an annuity table that you would use. Annuity table you use to allocate the money to the no power life tenant. So that is one way to save some capital gains taxes for the remaindermen. But you use the actuary tables that the IRS produces. The big advantage to either life estate would be it's immediately passed upon the death of the life tenant. So if mom has a life estate with no powers, remainder to 2 children, as soon as mom passes, you do not have to probate. All you have to do is show a death certificate, and you have full power to sell that property, lease it, do whatever you would want with it. So it is a great will substitute.
David, can I throw a question in here?
Yeah.
When you are looking at a life estate deed, so you just gave an example where mom may hold the life estate with children as remaindermen.
Yes.
Could you do a life tenant where you have multiple, life estate deed where you have multiple life tenants, such as a married couple, and both of them are listed as tenants? Are you able to write it in that manner?
Absolutely, and it happens a lot, Megan, as we were discussing with, divorces, and you have second marriages. So really, when you think about a life estate, see, a lot of people call me up and they say, I need a trust. I need you to do a trust agreement for me. Well, if their only asset is a piece of real estate, you do not need a trust agreement. A life estate deed with powers or a life estate deed without powers is really just a trust agreement for a piece of real estate. So a life estate deed with powers is really just a revocable trust. And a life estate deed without powers is really an irrevocable trust. So yes, we have drafted life estate deeds before that have read, husband has a full power life estate, Second wife has a no power life estate. Remainder interest are the two daughters. And then that's a little bit tricky. Are the two daughters going to be joint tenants, which means if one were to predecease, the other has the property, or would the daughters be tenants in common, which means even if they did predecease, husband and second wife, it would go to their children if they have children. And the only way you're going to really know how to advise somebody with that is to know what the family tree is, right? You have to know is where do they want it to go if everybody survives them, where do they want it to go if one person would predecease, do those people have children, what's the likelihood they would have children. So it's really just a matter of asking the right questions. We always try to draw a family tree out and then think of the contingencies and ask the right questions. But did that answer your question, Megan?
Yes, thank you.
Yeah. And then, is it a good idea to get a power of attorney signed congruently? Yeah, probably. What we do when we do estate plans is we would generally do a life estate deed with or without powers, depending on the facts and circumstances. And we'll go over some examples later on. And we would do a financial power of attorney, a real estate power of attorney, which is a specific power of attorney to the property. And we would do a medical power of attorney, and then a will. And again, we try to use the will only as a safety net, because we really don't want the families to have to probate. And a lot of things come up with sentimental rings and sentimental jewelry, and we really advise, especially if it's an older person, just to give those as lifetime gifts. If they want a daughter to have a nice ring and they want the son to have some heirloom, we advise really to give those out while they're living, and not worry and not try, instead of loading up a will with 100 specific requests. So no, the power of attorney is a smart idea. So a life estate. Go ahead. I'm sorry, Meg.
We have a couple, excuse me, we have a couple questions from content that you covered,
Sure.
so I want to get to those before we leave the topics.
Sure.
The first one is, does bankruptcy break a tenants by the entirities as well?
It does not. Here's the reason. So when you're holding as tenants by the entirety, and we advise couples all the time, if they're not married through a marriage certificate, to claim domestic partnership, fill the form out with the county, which the property says, and then we put the deed in T by E. And the reason we do that is, and how we think of tenants by the entirety is, if my wife and I have a property and we're tenants by the entirety, and she gets a judgment against her, when that creditor tries to levy that property, I can exercise my right as a tenant to own the entirety, which means as to her creditor, I own 100% and I block him. And this is really just from the old English common law, as to not this, they don't want spouses back in the old days when women didn't have as many rights. They didn't want women displaced from marital homes because of the actions of the husband. So they always wanted to preserve her ability to live there. And that law still, this old common law hasn't been adjusted. So really one person can exercise their legal right to own the entirety. So bankruptcy would not sever it.
Great, thank you.
Yeah.
The other question, you were giving an example where one life tenant, there may be one life tenant with powers and a second life tenant with no powers. And the question was, can you do that in the same deed, or would you have multiple instruments?
You can do it. You can do it in the same deed. And I think Jacob's on this call, and he's doing one now that he'll probably get to me soon. And it happens a lot with second marriages, because whoever owned the house, and then the second marriage comes, whether that's the whichever partner would own it, they generally want their new spouse to live in the house, have the right to live there until they are, okay you know, if they have to go to a home, that's fine, but not they want them to live there. And then they want it to go to their children, but not the second spouse's children. So sometimes you do those. If there's a lot of assets, you can do it through a trust. But if it's just the real estate they're talking about, you can draft. You know, we've seen life estate deeds with 5 pages of if so and so lives, if so and so lives. We've seen, no power provisions in life estates expire after 2 years. You know, depending on the age of a kid, they might want to give it a child to age 30, and then the property sold, distributed to everybody else. So you can do anything you would do in a trust, you could do in a life estate deed. You just have to be very, very careful with, and you'd have to, it's the same with a trust. You have to be very, very deliberate in your drafting to make sure you're meeting the needs of your clients. Does that answer your question?
It looks like we have a new one in the chat.
Right.
I think we answered that one as well. So I think we answered folks' questions. If not, please let us know. Thank you, David.
Yeah. So when you do a bare, we call it a bare life estate or life estate without powers. Basically, what that life tenant has is the right to occupy that property. So it's really almost they're a leased tenant in that respect. Now, if the remaindermen go to mortgage the property, the life tenant still must sign the mortgage. If the remaindermen sell the property, the life tenant must still sell the property, has to sign a deed to sell the property. Because in Maryland, a no power life estate to the life tenant is still a property right. Just like a full power life estate, the remaindermen have a contingent property right, but it's nonetheless a property right. Now the difference is with a full power life estate, the remaindermen are not vested until the date of death with legal rights, so they don't have to sign the deed or sign the mortgage if the life tenant with full powers would agree to, would want to do that. All right, I'm moving on if there's no more questions. All right, so effects upon the remaindermen. So we're going to talk a little bit about tax basis. Every asset somebody buys has a tax basis. So if you have a car, you have a tax basis. It's what you paid for. So if you do a life estate with powers, the remaindermen will get a basis in the property that's the fair market value of the home as of the date of the death of the life estate holder. So meaning it should reduce their capital gains to basically zero. So if I bought a house for $100,000 in 1990 and it's now worth $700,000, if I do a life estate to my children, when I die, if I do a life estate with full powers, when I die, their basis is $700,000, not a carryover basis of $100,000. So if they sell it for $700,000, they have no capital gains tax. Also, if I do a life estate deed with powers, the remaindermen do not have a legally vested interest until I die, which means if they have, if they want to buy a house of their own, if they're children and they want to buy a house of their own, they still are eligible for all the statutory first-time homebuyer grants. They're statutory for the discounts in transfer tax. Not that that's a lot of money, but there is still a little bit of a discount for a first-time homebuyer. So they would, excuse me, they would stay eligible for those credits. The other thing about a full power is the remaindermen do not have any control over that asset. The life tenant has control. So frequently what you see is that, and again, we'll talk about the Medicare impact soon, but a lot of times it's an evolving plan. A lot of times if people come to us and they're in their 50s and they may need a reverse mortgage in the future, or they may need to liquidate the property, we'll do a full power life estate just as a safety net in case they were to die unexpectedly. But if they're in good health and in their 50s, we're going to do a full power. And then we might, say to them, look, when you get to 70 or 72, come back and we can do a no power if that's what you want, and start clicking the top clock for Medicaid and all those things. So it's really, again, just asking their goals and how to do it. And so in a full power, the value of the asset doesn't attach to the remainderment. It stays with the life tenant, which means it is calculated into the Medicaid equations, and it is calculated as an asset into anything they would do with a nursing home. And it is also into the reach of creditors. So when you retain control, the risk is, when you're retaining control, you got to give something up, and what you're giving up is the ability for creditors to attach it, or the ability for Medicaid or a nursing home to attach it. On a life estate without powers, what the remaindermen generally get is what's called a carryover basis. So in my scenario, when I bought the property for 100 and it's now worth 700, if I do a no power life estate, that's considered a lifetime gift, and that gift contains a carryover basis. So when they go to sell it, they get a capital gains of 700,000 minus 100. That's 600,000. You're creating a $200,000 capital gain issue. Now, one item that could mitigate this would be if the remainderment, if it was just a parent and one child. One item that could mitigate this would be if the child was going to live there as their primary residence. Because if they were, they would at least get the exclusion under federal law for the $250,000 exclusion when you sell primary residence. So as long as they were going to stay there 2 years after the no power life estate, you can mitigate the capital gains issue that way. Same answer with the first time home buyer credits. If the remainderman would still, because it was an inherited property, they would still be, if they wanted to buy a property with a potential partner, then they would still be able to get the first time home buyer credits, grants, all those items, because they didn't buy this property, they inherited it. Now, with a life estate without powers, control transfers immediately. And this is very risky, very, very risky when you have multiple children, because they all might be getting along when the deed is executed and recorded, but you might have a disagreement. You might have two of them that want to sell, one of them doesn't want to sell, two of them want a mortgage to help the mom out or help the dad out. And that's where when you give up control, if something happens to that life tenant where they need resources, they need resources, they need the remaindermen to agree and to join in. And if one of those remaindermen doesn't want to compromise their equity in that house, either by signing a mortgage or giving it back to the life tenant to allow them to do a reverse mortgage, or selling the property and giving all the money back to the life tenant to check into a nursing home, you then have a family issue, and you have to work that out, which can be difficult at times. A life estate deed without powers will start the 5-year Medicaid look back time will start that ticking. So if you get more than 5 years down the road, then that asset and the value of that asset won't be part of any Medicaid calculation or any Medicaid. It won't be a Medicaid asset that could be liened. So that is the benefit of the without power. And what we've done with most of this is put it on a fancy chart for you guys. So we talked about passing assets through a will, how we would prefer not to do that, but use it as sort of a safety net because of the fees and the complexity of it. We talked about the advantages of a life estate with powers. I'm not going to bore you and go through them again, but it's in that chart. Talked about the advantages and disadvantages of the without. And then, again, the irrevocable trust, whether it's revocable or irrevocable, a trust can be, for people with multiple assets, it can be a great tool. But we generally do not recommend them. People's life expectancies now are, I don't know, maybe in the low 80s. I mean, that's something for us to think about when they're 65 or 70. But, we have a lot of people that are 40, 45 years old come to us and they want a trust. And it just can make it a lot more complicated because banks are going to ask for a lot more information. Lenders are going to ask for a lot more information. And if you're still at a very active time of your life where you're doing things with assets, buying, selling, mortgaging them, the trust is going to add a level of administrative and complexity to that we generally say, why don't you wait until you sort of got your life, you're older and you got your life kind of more predictable, if that makes any sense. All right, Miss Megan, I cannot see where the questions are coming in. So if I have a question, let me know. If not, I'll move on.
Yeah, we do. And can I take you back one slide for the question? There's a question posted and I have one as well.
Yep.
Okay.
Okay.
So the first question is, for a life estate deed without powers, can a creditor attach a remainderman's lien to the property if the life tenant is still alive?
Yeah, see, that's the other problem. That's the other problem. If you have, if you have 3 children and 2 of them are doing great and one of them is having some struggles, and you do a no power, you're basically giving that child that's struggling 1/3 of the equity in that property. And if that person gets a judgment against them or any of that creditor can attach it. And that's really the problem. And I was going to wait a second to discuss this, but I think the Medicaid part of the equation is a little bit overrated in that, but generally what statistics show that by the time somebody needs catastrophic care, they're really only in to a place for 2 or 3 months, and the deficit's normally 20 to 30,000. And there's some exemptions and some exceptions to how much of a lien Medicaid can file. So you're playing that hand against the tax basis hand and the risk that you're giving up your equity in your property so quickly that if a child has an issue, then you got a problem, because that issue is going to get attached to your property. And,
and this is a delicate balance that we certainly have to work through with our clients, because for many clients, the family members that they're hoping to leave their home to wouldn't have the financial capacity to pay off any Medicaid liens that attach. So even if it's a $10,000 lien, that may force them to have to sell the home and lose the home. So it is certainly important to understand and talk through with the clients the financial, stability of the potential remainderman and understand the different risks.
Well, they're going to have to maintain the taxes and insurance on the property. Now, I would tell you this, and I was going to get to this with the Medicaid part, but I'll give you a preview. Medicaid will not foreclose their liens. They'll put them as placeholders, but they're not going to foreclose and evict anyone. So there's if you have if you have a sibling or a child in the house, as long as they can pay the taxes and insurance, and Medicaid's never going to, what we would call, execute on their judgment. They may file a judgment for $20,000. They're not going to execute on it, which means they're not going to foreclose on it. So that judgment could sit there, for 20, 30 years. They're not going to enforce it. Now, if the remainder, if the person that's living in the house who's the proper heir or the proper remainderman, if they sell it, they're going to have to negotiate what's owed. But they're not going to. It's the policy of the government not to displace people from the home.
Okay, thank you. I have another question here. When you were talking about the first time, the tax basis, you highlighted that if the remainderman moves into the home and they're occupying it as their primary residence for more than 2 years, they may be eligible for that exclusion from capital gains taxes.
Correct.
If we're advising clients, and letting them know that this exception exists, is there anything, would you recommend that the remainderman take certain actions or keep certain documentation to support the fact that they moved in and used it as a primary residence to kind of protect their
Yeah.
interests?
Yeah, I think that I think if you guys look, in every county in the city has a domestic partnership application. Really, what that application is really almost proving a residency slash responsibility type thing. So if they would get on the utility bill, get on the cable bill, be part of the homeowners insurance where the property's insured in, mom and son, and so I think if you use those things, you're documenting your interest in that property, and then of course you change your driver's license, and that's on your voter registration, all those things. It's a facts and circumstances test, and that's how you would prove residency in that property.
Got it. Thank you.
Yep.
Before we move on here, I just wanted to highlight one thing that I don't think you touched on yet, but I wanted to let folks know about. So earlier you had talked a bit about joint tenancy and how that might compare with life estate deeds. One thing that's important when we're working with low-income clients for them to understand is that a benefit to using a life estate deed instead of joint tenancy is that many programs that are income-based, that are assessing whether or not someone qualifies for assistance with things like property taxes or home repairs, they're looking at household income. And so when an individual's on, if they're changing their deed to try to plan for the passage of property after their death rather than somebody who's living with them in the home today. Oftentimes a life estate deed better protects their interest because they can still income qualify for some of these programs. Whereas if they list their child who's working as a joint tenant, then it looks like their earning capacity is higher and it may disqualify them from some different programs. So that's another, when we're talking about eligibility for benefits, that's another consideration.
Agree 100%. And I think it's always prudent to keep the children off the deed until death. That's just me. But you're 100% right. 100% correct. Any more questions about the first? I guess we're at halftime of the presentation here. So, any questions?
That covers all that has come in. Thank you.
All right, moving on. So again, I won't read this chart for you, but it's a handy thing. And then, so Medicaid liens. The primary residence is exempt as far as their calculation as to if you qualify. Your primary residence is exempt up to $700,000. So most of our clients, and I'm sure your clients, are under that amount. So the home's not really going into it. So then it's really just income-wise, do they qualify for the Medicaid? And then, but don't confuse that. If a property's only worth $50,000 and there's a $20,000 Medicaid lien when they pass away, they will record, or they can record. They don't always do it, but they will record a lien on the house. It's just the $700,000 strictly for do you qualify up front from an income standpoint. But we'll talk about more when they can place it. And I tell you, they don't place. Again, I think in some respects the Medicaid liens are talked about. Too much emphasis is placed on them because there are exemptions to them, as we're going to see, and a lot of times they don't pursue them, or if they'll pursue them through the estate and not go back to the real estate. So, and here's what we were touching on before. So, while the person's alive, they can't lien the property. So no lien may be imposed against the property of an individual prior to death unless they get a judgment through the court, which they very, very, very seldom ever try, or they get a determination that the individual is an inpatient in a medical institution and it's highly unlikely they'll be able to return to the marital home. So once that person, either by death or by doctor's determination, cannot return to home to care for themselves, that is really when a Medicaid lien can be initiated and placed. Now, it takes Medicaid a long time because there are notices that go out, there's a due process, and you can challenge it. Okay, you can challenge it. And then if you have someone that's has some medical issues and cannot return to the primary home, they still won't place it. They still won't place that lien if a spouse is occupying that house, a minor child, or an adult disabled child, or a sibling who has an equity interest. Now that would be, as far as planning, they'd have to be a joint tenant, okay, has an equity interest. So that would be brother, sister, whatever, if equity interest for at least a year, okay, or an adult child that's been occupying for 2 years. So even then, if you have any of those scenarios, they won't place the lien. They won't place the lien at that time. All right. And then when they say no recovery may be made until the death of surviving spouse of the individual, that means they won't try to levy the home until that surviving spouse has passed. And then again, if you have a child under 21, they won't levy it. If you have a child that's blind or permanently disabled, they won't levy the lien. And then here's the sibling for 1 year or an adult child for 2 years before medical consistent showing they provided care that permitted the individual to reside there. So those tests are good to know. And again, they wipe out. I mean, you have a lot of those situations. In a lot of cases, mom's not great and daughter's moved home and daughter's occupying because mom needs help. If they've done that for 2 years, Medicaid's not going to come in and put the lien there. And I think that's just a public policy to where Medicaid wants to encourage that. You know, they want to encourage the children to take care of the elderly or to someone in the family to take care of an older person as long as they can without having to involve Medicaid or not having to involve a medical institution.
David, there was a question that came in, and this isn't really relevant to the homes that are clients, but for when folks are initially trying to qualify for Medicaid and there is the cap on the value of the home, do you know if that cap changes if the person is single versus married, or if it's just a standard
No, I mean,
value?
the way we read the statute, the way we've seen it applied, it's 700,000.
Thank you.
Yeah. So, I mean, most homes are going to be exempt. I think the average price of a home in the Baltimore metropolitan area is probably 300 or 330. Although it seems higher, I know, if you're young and you're trying to shop for one, but I think that most of them would be exempt. So with powers, again, we're going back to it. If you do a life estate deed with powers, that 5-year look back period never starts. And Medicaid, you know, assuming you don't have one of the other exemptions, Medicaid would be able to lien that property at your death. The life estate without power starts the 5-year look back period running. So if you gave a life estate without power in 2018 or 2019, your 5-year period's expiring now, and they would not ever be able to claim a lien on that property. So that's really the advantage of the no power, is to start that clock ticking. But you're measuring that advantage against the disadvantages of loss control, maybe creating a capital gains issue. And that's really where the rubber meets the road. Now, obviously, if you have a lower valued house that's been passed down generation to generation, if you pull the old deeds, you can kind of get the tax basis of it. You probably don't have a lot of capital gains in those properties. And you also have to understand that Medicaid really doesn't want to lien homes and foreclose them. So if you have an estate with no value, or people living of low means, they a lot of times just write the the lien off and move on. There's not really an appetite to recover these 100% of the time, based on my experience. Medicaid eligibility has a look back based, well, you're not going to see too many 3 years anymore. 2006 seems to me like a blink of an eye, but but it's I'm sure a long time ago for most people in this call. But after February 8, 2006, it's now a 5-year period. They talked about making it 4, but it's 5. And then the last part of the slide tells you when the look back period starts. So for an institutionalized individual, the start of the look back period is the first date they're institutionalized. So if your mom went into a home on January 1st, 2025, they're going to go back and look at her assets from January 1st, 2020 and forward. And if she gave you a house that was worth $400,000 for free, they're gonna make a motion if they have to put the lien on that house. Okay. For a non-institutionalized individual, to start is the later when medical assistance was applied for, or the transfer of an asset for less than fair market value. So in our situation would be if we transferred an asset on January 1st of 2022 for less than fair market value, we got to get past January 1st of 2027 to toll the 5-year statute. And then, so what they do, there's a calculation. I've never done it. I've never seen the spreadsheet, but if you get a notice of the lien, I'm sure it's in there. But if you don't toll the 5 years, if you gave away an asset for free that was worth $200,000, they're going to take that and divide it over a period of time, and that's what your income would have been, and decide whether you're still under the income limit or over it. Again, if that's only if you don't toll the 5 years. If you toll the 5 years, then you're sort of free and clear. But that's what this calculation does, and I think in the citations, Jacobs put the statute where that comes from.
I can give a quick example of
Okay, good.
how I use this with a client. So I had a client who wanted to do a life estate deed without powers, so that she could have that protect the home against potential Medicaid lien if she needed long-term care. And she is older, and so we talked about the fact that there was a risk of her incurring a penalty period if she needed that care before 5 years expired. And so I was able to find the tables and just give her a rough estimate of, if you were to incur the penalty, it could be possible that you'd be ineligible for up to 12 months. So when you think about who in your family would be available to care for you, do you think someone would be willing to provide you with in-home care and support for this period if you did incur the penalty? And that was just, one part of the larger conversation, but it allowed the client to understand the potential risks and what it would mean in reality for her if that did occur. Yeah, great information. And the one thing I want to add that's not in these slides is that in Maryland, it's very clear, the law is very clear, that the effective date of a deed is when it's out of the possession of the grantor. Now, I don't know if anybody's had to make that argument with, Medicaid or not, with the health department, but what that really means is if I do a deed today, giving it to my children, giving my house, if I do a no power life estate and give my oldest son, Tyler, 100% remainderment, and I sign that deed and it's property notarized, and I give that deed to my attorney and tell him to record it, or I give that deed to my oldest son, Tyler, and tell him, this house is all yours, buddy. Go, just record this when you have a chance. Tyler owns that property as of the date I signed that deed and I gave it to him. Actually, as of the date I gave it to him is when he owns that property. The recording is only for notice to other people. So, you could have, don't think you're sunk
because mom did a life estate with no power a year ago, gave the deed to the daughter, and the daughter didn't know she had to record it. There's a great argument that that 5 years started ticking when that deed goes out of the possession of the grantor. Because if you look at Maryland law on the delivery of the deed, that's what it says. When it's out of the possession of the grantor, the deed is valid as to the parties of the deed. So the recording just brings it into the purview of notice to creditors. So that's one argument. I don't know if anybody's ever made it, but you get that situation, it might not be as bad of a fact pattern as you think it is. All right.
Great, thank you.
We're going to move on. Again, the with powers doesn't start the 5 years because for Medicaid and for really as a matter of law, the assets are not considered transfer until there's death. So the life estate with powers, since there's a retention of control, you're not going to toll the 5 years. And then this is what Megan was talking about, how you would calculate the eligibility and that kind of stuff. So that's the thing you have to know. That's the thing you have to keep in mind. Excuse me. And then the without powers, you told the 5 years, and then it goes back. What you can do for the other thing that will mitigate the capital gains a little bit is if you did a without power and the remaindermen have a carryover tax basis, you can mitigate that if it's the remainderman's primary residence. But you can also, at closing, if your life tenant's still alive, you can use the IRS annuity tables to allocate her compensation based upon her life tenancy, what's the fair value of her right to live there. So you can allocate part of the purchase price back to the life tenant without powers, even though technically they've given the asset up. And that will reduce some capital gains for doing that. Again, that's all based on age and life expectancy. All right, any questions before we move on to the case scenarios?
I don't see any at this time.
All right, these scenarios were good scenarios, and they're tough sometimes to talk about. But client is 84 years old and has disability. She receives Social Security benefits as poor health. She would like for her house to pass to her son when she dies. Her son currently lives with her, helps pay the bills, and helps take care of her and her property. So if he's been there more than 2 years, they won't levy the house, right? So we'd have to know if she's been there more than 2 years. She has considered putting her son's name on the deed as a joint tenant, but was advised against in the past because he has a gambling problem. Client's home is her only asset, and she does not have a mortgage. Well, that's a lot of these issues in here between the lines are what we've kind of talked about. The fact that he has a gambling problem, although with these gambling apps, I see a lot of people betting pitch by pitch at baseball games now. So I think there's a lot of people that are gambling. But if he has a problem, there may be a chance he's going to run up credit cards, have creditors come after him. And if he's a joint tenant, they will be able to levy that asset and even foreclose that asset, foreclose his interest. So then if mom doesn't come up with the money to buy him out and pay those creditors off, she could be out of a house. So I would never recommend a joint tenant deed because you would have an at-risk child there, okay? I would want to know the tax basis of the property. And if you do a no power, what's the chances that she's going to live 5 more years to toll it anyway? If you do a with power, you may preserve some tax attributes for her and for the son, and then keep it out of the son's potential creditors. So that's how I would look at it. I probably would lean toward because of her age, because of her son's issues, I would probably lean toward a full power. Makes sense? Anybody want to else chip in their 2 cents?
I'm gonna give folks a minute to,
Yeah, and I think Son would mitigate. Let's say Son gets his act together. Son gets his act together, and he gets the house. If he lives there 2 more years, even if you did a no power, you're going to put it at the risk of the son's creditors, his interest. But he probably could mitigate the capital gains issue because he's lived there. But again, you got to kind of figure out how bad. And you can run, look, we can run judgment reports on anybody now. So that doesn't mean it's going to stay that way. But you look at risk and reward, and that's what I would do. I'd probably run judgments on the son, try to analyze that, analyze the tax basis. Based on what I know, I think I'd probably go full power, but because of her age, thinking I'm not going to make the 5 years anyway. If she was 74, it's probably a harder decision.
mm-hmm.
And you got I'm sorry, Meg.
I was just gonna say, in this fact pattern, it says that she receives Social Security disability benefits. I'm not aware of life estate deeds creating any issues for people with that benefit type. Are you aware of any
No.
concerns there?
No.
Okay.
She should be fine. She should be fine either way, whether she would do it with or without power. But again, I don't know what would the impact be if she went to a joint tenant. I still think Social Security goes to the person and not to, I don't think they'd consider the son's income, but I'd have to check that. Depending on what I guess she's on some full or partial disability.
We have had a couple more questions come in that aren't specific to this scenario.
Okay.
Would you like to take them now or at the end of the scenarios?
Yeah, I'll take them. Take them now. Might as well.
Okay. One question is referring back to the conversation we had where you said that you could do kind of like multiple life tenancies within one deed. And the question is whether you've seen drafting issues with that create a cloud on title. The concern being if we try to do, too many things or make it fancy, it might create a new issue.
Well, I think you just, like anything else you draft, whether it's a will or a trust, you just have to be as clear as you can be as to how you want that asset to pass. What you do create when you do it through a deed is if somebody needs a mortgage or a reverse mortgage or wants to sell the property, it is going to take the consent of multiple people because, like I said, even a bare life estate creates a property right. So they would have to consent to the sale. But you can be creative with your drafting. And again, I think the trick is if you have a scenario where you have to do multiple interests in the same deed, you would want a second set of eyes on that really didn't know anything about what you were trying to do and have them tell you what they think, so to speak.
Could you talk a little bit about, so you just mentioned that you would need consent to, for example, open a new mortgage. What if there's an existing mortgage on the property when you're meeting with the client? How does that impact whether or not you can execute a life estate deed?
Well, you still can because it's first and right, first in time. So the mortgage, the person who holds the mortgage hasn't been compromised because the interests of the remaindermen are subordinate to them. So they could still foreclose on that mortgage and foreclose the remaindermen's interest because they're ahead of it. First in time, first and right, which is why in our world, we want to rush getting documents to the courthouse because we want to shrink our gap period and provide that notice. And we want to vest our rights, so to speak. So that's really where the rub is on that scenario. But they're taking it subject to the open mortgage.
Okay, so you're not concerned when you're working with clients, you're not concerned about
No.
the execution of a life estate deed potentially triggering an acceleration of the mortgage, for example?
No, there's a due on sale clause in the mortgage, but if there's a federal law that says as long as you're not selling the property, if it's part of an estate plan and it's heirs and you don't trigger the due on sales clause.
Thank you. That is a
Yeah.
frequent question that we
Saint
ponder.
Germain, it might be called the Saint Germain Act,
Okay,
but it's clear that that wouldn't trigger a violation of the due on sale clause of the deed of trust or the mortgage. Anything else?
I think there are some more. Let me scroll here. We've covered a few of them. Okay, we have a question here. It says life estate deed without powers will not help Medicaid eligibility, just helps with probate and can have a Medicaid lien. So the person that put this question in, I'm not sure I'm understanding the question, but I can, if you'd like to ask the question, I can push a button here that allows you to talk if you want to jump in and maybe clarify the question for us.
Hi, yes. So my question was related to scenario number 1. So in this scenario, if we're doing a life estate deed with powers, this is not going to help with the Medicaid eligibility. Is that correct?
You're not going to start that 5-year period running.
Correct.
So
So that will be counted towards the resources.
yes, it will be.
And would the 700 exemption for the house help with the Medicaid lien not being put?
Well, the 700,000 is not for the lien. They'll lien a house that's only worth 100 if they have a $20,000 lien. So the 700 is just they exempt that from the income calculation.
When someone's initially trying to qualify for
Somebody's
Medicaid.
initially trying to qualify, yeah.
I see. Okay. And the fact that the son, if he stays there with her for at least 2 years, will that help the Medicaid lien?
Yes, it would be great because even though they may put a lien in on the house after she died or could not return home, they will not foreclose that lien. It would just sit there. And then if the son sold the property, 10 years down the road, he would have to negotiate it out then.
Okay.
Yeah.
Thank-
And as a practical matter, if that son's in that house and he's been there more than 2 years and it's a small lien, they won't even lien the property. They'll move on and close their file 99 times out of 100. I have probably reviewed 150,000 titles in the state of Maryland during my 32-year career, and I think I've only seen 5 or 6 Medicaid liens. So I do think that you have to plan for it, but I also think that there is a policy that they're really not going to take the equity out of low-income people's houses if that house is trying to be passed down the family tree.
Okay. So in this scenario, if the house was $1 million and the exemption is 700, so only 300,000 will be accounted for towards the resources for
That's
Medicaid. Okay.
That's correct. That's correct.
And in the second question, you also mentioned about, the properties with mortgage on it. So do you have to inform the lenders prior to recording the deed with powers or without powers?
No, there's a Saint Germain Act that says it doesn't trigger the due on sale clause and they're not entitled to notice.
Even if
happens
it's without powers?
even without powers? Because remember, yeah, go ahead.
I'm sorry. I was just wondering, even if the interest vests right away, it's a lifetime gift. So will that not trigger kind of a transfer of
It's
the
not
interest?
it's not considered a sale because you didn't get compensated for it.
Okay,
It's
gotcha.
a different if you read, it's the Saint Germain Act. And it's different if mom was living there and she said to son, hey, I need some money, whatever. I'm going to sell you my house for 300,000, and he pays her consideration of 300,000. Then I think you've triggered it because you've gotten compensated. But if you're without compensation and you're doing estate planning and the deed is going to vest with a family member either currently or at death, you're not violating the due on sale clause, and that's just it's a Saint Germain Act, I believe is what it's called.
Okay. So you're just hoping and praying the 5 years pass by before the Medicaid eligibility turns in. Okay.
If you do a no power, you're hoping that the 5 years goes by.
Right.
Yeah.
Okay. Thank you so much.
Oh, no worries. Anything else,
That's
Meg?
all,
All right,
that's
I'm
it.
gonna
Let's go to the next scenario.
let's do it. Client is 62 years old now. See, to me, this is young. To some people on this call, it's probably old, but to me, it's young. Client is 62 and has two adult children. Client's only income is Social Security, and she's in good health. She wants to leave her house to both children and avoid probate. Neither child lives in the home, so that's an issue, right? Because you're not going to get the Medicaid exemption there. And both have their own homes. Client's home is her only asset. She does not have a mortgage, but she does have credit card debt. Well, if you go no powers, you start the 5 years. She's still pretty young. She's just drawing regular Social Security and she's in good health. I think I would do with powers now. Again, got to know the tax basis. If there's a lot of capital gains wrapped up into that, I think I would do no powers now and then schedule another meeting with her 4 or 5 years down the road and see if she'd want to convert it to a, I mean, I'd go with powers now. I'm sorry. I would go with powers now and then have another meeting with her 4 or 5 years down the road and see if she wanted to convert it. A lot of times what we find, and we get this scenario a lot, the client who's 62 ends up selling the house anyway, and then, you know, buys an Ocean City condo or moves to Florida with her sister or something like that. So 62 is probably a little young to go without powers, I would think, unless there's very little tax gain in this property. And then it seems like she has 2 stable children, so you don't worry so much about them having control. But you have to understand if she goes without powers and then wants to mortgage the property or sell it, she will need the consent of her children.
So one of the questions that's been raised around a scenario like this by a member of our team is whether, you know, if the client wanted to do without powers, whether you could pair it with a financial power of attorney where her children would be granting her financial power of attorney over the property to still effectively have power, kind of like as a workaround. Is that a viable option?
Well, you would do specific power of attorneys for the property, and yes, you can do it. But here's the problem: you'd have to put a gift clause in that power of attorney that she would be allowed to gift to herself. And then you don't always know if a bank or a title company is going to accept that power of attorney based on this fact pattern. That's the tricky part with these power of attorneys. You know, people take them into banks and or take them someplace, and the person says, I can't rely on this because I'm not uncomfortable, or I found an issue with it or whatever. So you got to be careful. I'm not saying it's not a good idea. But I probably would go with powers, try to schedule a follow-up meeting. And again, if there was the only way I would go without powers so soon is because seems like she has 2 reliable kids that won't create a problem. And if there was a low tax gain in the property. Anybody got an opinion on scenario 2?
I don't think this question is specific to this scenario, but there is a question about if the client has, if their assets include a house and retirement fund, do you recommend a life estate deed without powers?
Well, I think it's the same analysis. The retirement fund is out of the reach of creditors. So I think you go through the same analysis. What she or he should do with the retirement fund is just make sure they have a clear payable in that election with that. But that's outside the purview of the creditor. So I don't think it really comes into with powers or without.
Thank you. I don't see any other questions. We could go to the next scenario.
All right, let's see what 3 are. This may be the one where we have to do some creative drafting. All right, clients A and B are married couple in their 40s, again, young to me, with teenage children. They still have a substantial mortgage on the property, and the house compromises most of their wealth. They bought the house while married, but only A's name is on the deed. Well, that's not good. You should always hold the deed as tenants by the entirety, because you will block the creditors of the other person. A works full-time in construction and B receives disability benefits. Well, I still think the marital home is not going to harm B's disability benefits. We have to check that out, though. They have minor credit card debt. If they pass while their children are minors, they want the house to go to A's sister, who will take care of the children. If they pass after the oldest child is 21, they want to go to house children. So here's what I would say. They don't want how I would structure this is, I'd have to research the type of benefits that B is getting to make sure giving her a life estate interest or whatever is not going to harm those benefits. If you can give her a full interest, you would give her a full interest. It doesn't say, I don't think, if she's mentally or physically disabled. I mean, but again, if she's mentally disabled, it's probably a different calculation. I wouldn't want to give the property to A's sister. I'd want to have a remainder to a uniform minor trust for the children. And then if they were older than, well, it's 18 for the minor trust. So if they don't want to do that, you'd have to leave it to a trust or set up a trust. So this may be a scenario where you don't use a life estate deed, or you use a creative life estate deed where you would give wife that's on disability just a bare life estate. Husband A would retain a full power life estate, and then upon their death, if the children are over 21, it goes to the children. If they're under 21, it goes to the sister, but it would go to the sister in trust until they're 21. I don't think you'd want to give the sister an outright interest. You give her an interest as a trustee, and you don't have to have a formal long-term, long trust agreement to do that. If you denote her interest as trustee for my 2 daughters, Jessica and Emily, until they attain the age of 21, you've in a sense created a trust in that document. And there's statutes that tell a trustee what they can and cannot do and what their fiduciary responsibility is. So you wouldn't need this elaborate 40-page trust. Now, I just gave you guys a lot of analysis in a minute, so I'm sure there's questions. So I'll take a deep breath and see how you guys view this one.
Yeah, so the first place I'll start is just to share transparently that we at MVLS don't take trust cases. So we stick with wills and deeds as the kind of mechanisms for transferring property through estate planning.
Okay.
When you're, and sometimes people will ask us, when is a trust advisable? And this is one of the scenarios where we say, if you're trying to pass property that you want someone to take care of for somebody else who's not yet able to manage it. But in this scenario, is there a reason that you would advise against doing this through a will? Because when I first wrote this, that was kind of in my mindset of, it seems a little early for accomplishing through a deed what they're hoping to do, because there's a lot of contingencies. And so I would probably have started with a will. What are your reactions to that?
Will would be cleaner. Again, you're going to create some cost and time, but you're right. The will could be cleaner because you can make the provisions for your 2 children much easier. They're also still young, so the likelihood that they would both die is very, very small. So yeah, but you'd really have to do, to me, Megan, I'd have to really look at, can we put the wife as a tenant by the entirety without messing with her disability? And I think you can in most cases. So if you could do that, and then you just do a basic will that says if the children are under 21, the property goes to it would go to a trust until they're 21, and you could put the trust in the will. It's not, or the rules in the will. It's not bad. Now, the rub is if you could convince A and B just to use a uniform trust, minors trust, you could do that very cleanly in the will. But they would be able to get control of that house at 18. That would be the thing they'd have to think about.
Okay.
Yeah, but you're right. Will may make this one easier.
A question that came in, I think at one point you used the phrase bare life estate, and so the participant is wondering if bare life estate differs from a full life estate, or what you meant when you used that term.
A bare life estate is a life estate without powers, because you really only have the right to occupy the property. You don't have the right to mortgage, pledge it, sell it, do anything else with it. Your rights are basically you can live there. So we would call them bare life estates. Any other questions about scenario 3?
I'm not seeing other questions here now.
Yeah, I mean that's probably the tougher of the 3 so far. All right, let's
We'll
see.
move to our last one.
We'll do 4. Client is 75. Now, to me, that's a little bit older, right? But he's in fair health. She's in fair health. She bought her home with her deceased husband, and they are now both named in the deed. Well, that's actually good, because she would have got to step up in basis for his share when he died. She's about to be remarried and is considering changing her deed. Well, that gets tricky. This is the second spouse syndrome here. She wants her fiance to be able to live in the home if she predeceases him, but she wants the house to go to her children, not his, once they both pass away. There is no mortgage on the property. Client's income is Social Security, and her fiance is the SSI. So that we're actually doing a deed just like this. So what we would do is client, the missus, would do a deed to spouse as a bare or a no power life estate, letting the spouse live there. She would retain a full power life estate, and then when spouse dies, it would go to her children. And then you have to figure out if you want her children to be tenants in common or joint tenants, and then that would be determined by do they have kids, those kind of things. So that's the analysis there, and we're doing one just like it now.
And the other fact I threw into this one was that her fiance is on SSI. We are still at MVLS developing our understanding of how different types of benefits play a role here, but I do know that of the different types of benefits, SSI is, I guess, an orange flag or a red flag to look into, because I do think that type is more sensitive to asset transfers and how it could impact somebody's benefits.
Right.
So I don't know if it would impact the planning here, but I do just want to let folks know that if you know that the person giving or receiving a property interest has SSI, it's something that you want to investigate.
Exactly. Yeah, you got to, and that's part of probably the first analysis. But I would think there is a value. Obviously, it is a property right, and there's a value to a bare life estate. Again, there is public policy that you don't want to displace people from homes, and you want them to have appropriate shelter. So I would, if I'm guessing, I don't think you would have to, that would impact the benefits, but you can't be too careful, because frequently these are hard to understand and are ever changing. So I agree with you, Megan. Got to analyze that also.
We have a question from the last scenario. Muriel, do you mind if I unmute you and allow you to ask the question aloud so that I don't butcher it? David, you want to scroll back to number 3?
Yep. Okay.
Just to keep something really simple, because that's what we're interested in doing, simple stuff or fancy stuff. We send clients to attorneys if they can afford to get fancy. The question is, if you're doing a life estate deed and you want the remainder to go to a minor child, but you have a good custodian in mind, Can you just make the language as simple as, you know, life remainder to A as custodian for B under the Uniform Transfer to Minor Act? And that could that be the only language?
Yes.
Okay.
Yeah. And if you don't want to use the uniform, because in your scenario, the child would get control at age 18. If you want to make it 21 or 25, you would just say to party B as, you know, custodian / trustee for my minor child, Jessica, until she reaches the age of 25. At such age 25, Jessica would retain full, would be granted full ownership of the property herein. Very simple, just like that. And you don't need a formal trust agreement. You really just need, because there's statutes that tell you what your rules are. You know, what trustees can and cannot do, what their fiduciary responsibilities are.
Thank you.
Yeah, good question.
Okay, great. We have about 8 minutes left. Are there any other questions from attendees? This was our last scenario, so we have a couple minutes here for other questions that may be coming up for you.
Yeah, Jacob put some citations back here where we got this information, where the U.S. code is. So, but that's it.
You give folks a couple minutes to think about any potential questions. And I'm putting my email in the chat. If folks want to follow up after this for, you know, questions you think of after the training, or if you want to learn more about volunteering with us, please feel free to reach out.
Yeah, and you can give them my email too, Megan. I'm happy if they need help. And
okay, I'll include, so I'm going to send out the slides afterwards, and I'll certainly include contact information there.
Yeah, we have a good forms. We have a good real estate form library over here. So if you need anything to do with a piece of property, we probably have a form that meets your goals or something close. And Jacob and I are happy to share them.
Okay. And we do have another question here. Does a married couple retain their tenants by entirety's protection when they execute a life estate deed with both of them as life tenants?
Well, you would denote that in the life estate deed. You would say, you know, party A and party B, husband and wife, or a married couple, I guess is more appropriate, married couple as tenants by the entirety, which means they would have survivors. So the remainderman wouldn't vest in a life estate with full powers. The remainder wouldn't vest until both were to die, or the last were to die. So you still have to denote the tenancy of the life tenant. In most cases, they're sole because the spouse has already passed, or there's been a divorce.
Looks like that's all the questions that are in. David, on behalf of the whole group, I want to thank you so much for your time. This was really valuable. It was great that we were able to ask so many questions as we went along. It was really useful. For the folks who are joining us, you will receive a follow-up email with a survey. Please complete the survey, give us feedback. We're always hoping to build out our resources, add more offerings, and we do value what you think went well, what you want to learn more about. Any of that feedback is useful to us. And I will also be following up to share the slides as well.
Thank you, Megan. Happy to help. And like I said, guys, anybody that was on the call, if you need anything from us, just get a hold of myself or Jacob, and we'll be glad to help you.
Okay. Thank you so much. Enjoy the rest of your afternoons.
All right. Thank you.